It's our big focus this hour. The draft of the anti-rape bill, which the Mamata Banerjee government is set to present in the West Bengal Assembly tomorrow, proposes capital punishment for those convicted of rape if their actions lead to the victim's death and even if the victim survives. The draft also proposes that people convicted of rape or gang rape will face a life sentence for the rest of their lives. It's called the Aparajita Women and Child Bill 2024. The new law aims to better protect women and children by amending current laws and adding new rules about rape and sexual offences. The bill also proposes to amend the Bharatiya Nyaya Sahita 2023, Bharatiya Nagrik Suraksha Sahita 2023 and the Protection of Children from Sexual Offences Act 2012 as they apply to West Bengal. The amendments aim to increase penalties and create a framework for faster investigation and trial of severe crimes against women and children. The big question then is, can a state enact legislation to impose capital punishment? While we understand this sentiment, is this possible? Well, let me quickly open this up to our panel. Live with us is Ramakant Gaur, Supreme Court lawyer. Also with us is Naveen Chomal, senior advocate. Kailash Vastev, Supreme Court lawyer, also joins us live. N.S. Napinai, senior advocate, also is joining the broadcast. Welcome all of you and thank you very much for being with us today. Ramakant Gaur, let me begin with you first. What do you make of this legislation that the West Bengal government intends to pass tomorrow?
See, the intent appears to be good and the intent appears to be really giving a message to the society that they are serious. But the question which is of pivotal importance is whether they were serious earlier. Are they really serious in executing this? Or is it a lip service? Existence of any legal provision in India doesn't mean anything if that is not being properly prosecuted in the courts of law. The courts in Kolkata and West Bengal specifically are flooded with litigation because of want of prosecution. Not only in rape cases, but in almost in all cases. So when the central legislation provides ample provision for the punishment, bringing capital punishment may sound very well politically, rhetorically, but whether that will really serve the victims and their families, whether they will get the justice, and more particularly in view of the fact, when a rape is committed and such a gory incident was committed, it was termed as suicide. So the intention is always in question when execution comes to the fore. When it comes to the rhetoric, West Bengal comes ahead from all other states in the nation.
Yes, let me in fact throw that open to Naveen Chomal as well. Naveen Chomal, do you believe this is a step in the right direction? What do you make of the tenets of this legislation that the West Bengal government has come out with? Naveen, can you hear me? Okay, I think we're having some trouble with this connection. Kailash Vastev, why don't I throw that to you if you are there with us. Kailash Vastev, this is of course a legislation that obviously has come about because of the uproar that we've seen in Kolkata with regards to the RG car case. But is it a step in the right direction? What's your take?
Good evening. See, the fact is this. The amendments or the new law which have been passed, the various criminal laws, have changed the concept of punishment for rape in Chapter 5, Section 64, 65 onwards. They made it 20 years or imprisonment for life with no remissions. Now, you are trying to bring in a death sentence for the purposes of rape, which is always a questionable action because a death sentence is not a remittance, is not a deterrent at all. Give you an example. In our country, the convictions in rape cases range between 20 and 28%. The problem is not the law, the problem is policing. In the Calcutta case, the problem is not the law, the problem is politics. The biggest problem in Calcutta today in this particular case is destruction of evidence in the conflict between the CBI and the local police. You've got to have material on record to indict a person and eventually convict him for rape. Theories are being propounded all the way through. I'm giving you this to say that merely increasing the number of the kind of imprisonment which a person would face is not a deterrent. Deterrent is immediate action. The second aspect which we must remember is the tremendous delays in court. I was going through some of the judgments which have come in the last 5 years in the Supreme Court pertaining to rape. They relate to offences which are more than 10 years old. In some cases, there have been acquittals. In some cases, there have been convictions. But where there is an acquittal based on a false case, that man's life is destroyed because they are all basically in the life age of between 22 and 30 in the cases which I have read. Do you imagine what you've done to their lives? Therefore, what is necessary today is a very fast-track court. They began it in Rajasthan, time limit 6 months. They began them in UP, time limit 8 months. They began them in the Punjab, where they said, no, we must have fast-track courts for these kind of offences where the lives of ladies are involved and they have to be given protection. But the fact is, the police is incapable of an expedited trial because they have interests which are backed by political needs. You're seeing that in Calcutta. You are seeing it in the case of the recent trip of the girl, of the lady in the Sion hospital. You saw it in the case in '73 when the nurse was raped in the hospital in Bombay. The man was convicted only twice for 7 years each. So the deterrent is the police. If they don't act, you are not going to have an answer. It is time that a police system and our judicial system woke up to this serious problem. You made the amendments in 2006 to the IPC. What is the result? Same conviction rate drops from 28% to 22%. That is not an answer to this. You may have the best of laws, but if you cannot implement it, they are of no consequence. Calcutta is a place where women were safe on the streets. Today they are frightened. It was the same for most of the Northeast, where ladies were by and large safe at all points of time. As of today, it is not so. North India has always had a bad reputation in the matter of women and their freedom. But now it is spreading all over. It's a social situation which has to be dealt with in different directions. Policing has to be changed, and we must have the courage for the purposes of the judiciary to carry out fast-track courts. If you don't have that, create all the laws you want in the world, you're not going to find a solution to this problem. That's my view.
Yes. Okay. N.S. Napinai, what's your take on the issue? Do you believe this is a step in the right direction? What do you make of the punishment that it sets out and the other parameters as well for a rape accused? N.S. Napinai.
See, if we look at it very clinically, the first and foremost is, can a state government bring about this amendment? Of course they can. It's in the concurrent list. Is it needed? Is the second issue then. So we've talked about what are the provisions already and how even what exists is not has not had a deterrent effect. We need to look beyond that and to see what exactly do you have. You already have provisions for rape and for aggravated forms of rape by people in authority, etc. But one provision which seems to have been missed out, and therefore I wonder whether there is a redundancy, is section 66 of BNS, which clearly says that if you, in the process of committing rape in either form, which is part 1 or part 2 of 63 and 64, if you cause death of the victim, or even if you leave the victim in a vegetative state, then the minimum sentence is 20 years and it could extend to life for the rest of your life without remission, or death. So you already have death as a punishment in terms of rape, where death is caused in pursuance thereof, or even where the victim is left in a vegetative state. Has that helped victims in terms of deterring crimes against them? I don't think it really has. The next thing is, if this amendment is being brought about as a political move, I don't really see how it is going to help the victim or their families to gain justice in this particular case, because whatever law comes up can only be applied prospectively, it cannot be applied retrospectively. So you cannot try to apply a state amendment to the KG car case, to put it very simply. You can only apply it to a policeman, and if he fails to register it, then he is to be held guilty. Okay? And there is a sentence involved. Now that same provision forms part of BNS also. It was 166A under IPC, and now you have it under 199 BNS. Now, my worry is this. We've talked about how the laws are not being implemented and victims are still struggling even to get through the first level. The first threshold is for their complaint to be registered. Now, why is it that we are not seeing a provision that was included to obviate this problem not being implemented effectively? How many victims really know that they have this remedy also? Where do they find this remedy and how do they exercise their rights under this remedy? The reason I'm pointing out this particular provision is law has taken note of the fact that there are issues, there are concerns that impact victim rights, and therefore there are certain guardrails that have been placed within the parameters of law. Unfortunately, we always say the human is the weakest link. Here also, in terms of implementing the law, the human is the weakest link. I'm not going into the why or how of it, but the bottom line is it's not about law or the sufficiency thereof. It is about how well it is being implemented and where is it being circumvented or being ignored, and where are we finding the remedies where the law is not being implemented effectively.
We've got to find the remedy in court also. We are letting ourselves down there. That's the sad part of it.
Yeah. But the wider point, of course, also is, Ramakant Gaur, and yes, you can come in also to respond, that we do need to fast track such cases. The frustration is there with the system that why in rarest of rare rapes also there is no fast track punishment currently being given.
Sir, Ms. Mamata Banerjee has written a letter to Prime Minister Modi about the fast track. Let me give you the stats of fast track courts. There are 88 fast track courts in West Bengal. Yet there are 48,600 rape or POXO cases are pending. This is today's Mint's report. So this is the pathetic situation. Kailash Vasudevji has raised a pertinent point that police does not take action. Police go by the will of their political masters. And that is the only reason why Prakash Singh's report could not be implemented in spite of an existence of a Supreme Court's guideline, direction on this, and no political party whatsoever it is interested in making police free to take action. Unless police is free, unless police hands are tied, they cannot take action. They are not able, or they do not take action to register even an FIR. You go to any police station, and I'm not saying about you, me, or anybody else. A Supreme Court judge who happened to be judge number 2 in Supreme Court, Justice Agarwal.
That's right.
He went to police station in Darapuram. He could not register an FIR, and that's the reason this laid down, the foundation of Lalita Kumari's judgment. And even after Lalita Kumari's judgment, which is a constitutional bench judgment, you cannot go and register an FIR unless you have very influential backing and somebody from higher up says something to SHO and he'll not register the FIR.
You just see what the president said day before 3 days ago. And the judiciary has to reform.
Sir, they have been saying it. They have been saying it. We have a proactive.
What do you want?
We have a proactive Chief Justice.
Yeah. No, we are being chastised by the authorities for our failures, and we do nothing to remediate.
Absolutely, sir. I'm very clear about that, and that's the reason they do politics. Anyway, on Manipur, the same president.
No, come on. At the end of the day, the system also should look inwards. There is introspection needed as well. Why is justice not being delivered? Why is the judiciary also failing our women? These are questions, legitimate questions that are being asked by citizens of the country, Ramakant Gaur. Yes, Naveen Chomar.
See, I would like to beg to differ with Sri Kailash Vasudevji. I have been practicing as a criminal lawyer for last around 30 years, and I have been working in the field also. I must have visited and interacted with the police over thousands of times in the police stations. So I'm not boasting about of any personal reminiscence, but out of experience, I'm sharing with our esteemed viewers that we have come across various frustrating cases where police are not registering offences when they don't want to. But generally, those cases occur when there is a money transaction matters, cheating case, fraud case, forgery case, or the cases of that nature. Sometimes fight between two groups where they want to favor a group something. But by and large, since decades, our police has been very upright, at least in the cases of rape. Whenever there has been a case of rape, police has always been honest and they have been particular in getting the offence registered. The investigation is also fair. Of course, there must have been certain exceptional cases everywhere. I am not denying that. But very rarely have been the cases where police have denied what is the justice to the woman in such cases. Maximum in the case of dowry demands, maybe the police must have shown lethargy and favored some side. But in rape cases, police have always been very particular. But now coming to the topic that we are discussing today about the Mamata government, this is particular different case.
Yes, this is politics. You made the point earlier. Naveen Jamal, you made the point earlier that this is political point scoring. But how do we ensure fast-track justice? Do you believe these tweaks are needed overall? Because the wider point is, of course, rarest of rare punishment for rape accused and, of course, fast-tracking trials as well of rarest of rare cases.
So our judiciary is also very sensitive towards the rape cases. All over the country we are seeing the judges are highly respectable, at least the Sessions Court judges. They are taking rape cases very seriously. So fortunately in our country there is no hue and cry about the thing. The issue that we are discussing is whether the special assembly session called by Mamata Banerjee and try to demonstrate to the public that she is changing the law for the betterment of the woman, that is all farce. And it is all a fraud being played on the public and nothing else.
Sir, 48,600 cases pending in 88 fast-track courts shows everything.
Right.
How every limb of the system is working.
Okay.
That's static.
Then may I come in for a second?
Yes, very quickly. I'm out of time. 20 seconds.
Yeah. So I would just want to reiterate that, the investigative process forms the foundation for any case. So we really need to make the system work from that stage. And, the second step is, what I usually...
Yeah, that's unfortunately where the many say the Kolkata police also didn't do a very fine job.
And evidence is a breadcrumb trail. So if you don't catch it early, you're going to watch it disappear.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.